I think to me, because I have a family, it means that my family is healthy and happy, pursuing what they want to do and their passions. And I'll add one more caveat to that before I get too wordy with this, and that's having the opportunity, an equal opportunity to pursue one's dreams and and ambitions. Because I think that fundamentally, if we get really philosophical, is what makes people happy.
Welcome to the Verdict Signal podcast, where we feature how top attorneys help people make informed choices, avoid common mistakes, and move forward with confidence. Now, enjoy the show, and here's your host.
Daniel Gao here. I'm the host of Verdict Signal, and today we're expanding our conversations to the experts who protect what people build, their careers, families, and businesses. I have Shayna Fernandez-Watts, who didn't start out fighting for workers and women. She started out on the other side of the table. After launching her legal career defending employers and companies in big law, she made a deliberate pivot, founding her own Arizona-based practice built around representing primarily employees. Today, her work centers on some of the most consequential issues in the modern workplace. She advocates for women facing pregnancy discrimination, sexual harassment, and unequal pay, and also takes on cases involving disability accommodations, unpaid wages, and non-compete agreements. Before law school, Shayna spent time in the classroom rather than the courtroom, teaching US and Texas history with Teach for America in Donna, Texas. Shayna holds a master's in curriculum and instruction from UT Pan American, alongside a BS in human biology from Stanford and a JD from the University of Arizona, James E. Rogers College of Law. She also co-teaches the Civil Litigation Experience Practicum at Sandra Day O'Connor College of Law, and she serves on the local rules committee for the U.S. District Court for the District of Arizona. So Shayna, welcome and glad to have you here.
Thank you for having me. I'm very excited to be here. So, topic we are going to be discussing is very near and dear to my heart and my practice. So, glad to be here.
Yeah. So let's start at the very top, Shayna. How did you first get interested in the legal field?
I don't think I realized I wanted to be in the legal field until college. I thought that I wanted to be a doctor because that's what um, I had always imagined myself doing, and that was what I understood was a great way to help people. When I went to Stanford, I quickly realized that the sciences were not really my passion, especially organic chemistry
Mhm.
was not my favorite subject. We'll just say that. Um, and I did alternative spring breaks. I did two of them. One was in San Francisco, and the other was in New York. And it was on women's rights issues, and it was on access to harm reduction programs and treatments and policies and all the things surrounding that. And as part of the coursework, before we could go do the work in the communities, we had to do a lot of research and reading on those topics and how they impacted the communities around them. And I just really got more interested into the policies and the laws and really felt like that was what I wanted to do. But still felt like I needed a little bit of time before law school and did Teach for America as an opportunity to also kind of give back to the area I grew up in. So I'm originally from Brownsville, Texas, which is all the way down on the southern tip of Texas, if anyone's familiar and has ever been there. It's a very unique part of the country. It's a wonderful city. It's now where it's very near where SpaceX is, if anyone knows where they're doing all the launches, and Boca Chica Beach is right there. But I returned to South Texas to do Teach for America in Donna, which is about an hour north, so to speak, of Brownsville, still very South Texas. And then, I just confirmed, I studied and applied to law school from there. So that's kind of my way to law school, a little bit
Okay.
unique, I think.
Okay. And what led you to focus primarily on employment law?
Yeah, I speak with a lot of students and both law students, college students about that. And I think that I didn't really focus or think that that was all I wanted to do when I first graduated from law school. So when I graduated from law school, like many other students, I had student loans,
Mm.
right? And I really needed to figure out what my job was going to be after law school. And I had an opportunity to work with big firms and knew that that would also give me the opportunity to explore different practice areas. Because in when the big firms I went to, they really give associates the chance to kind of work for different partners in different practice areas. And so I did that, and I really found my interests were more aligned with what was happening in the employment law practice group. And so that's kind of where I try to gravitate my time and my work.
Okay. And what's one thing that you wish more people understood about working with an attorney?
Oh, that's a great question. Um, One thing I wish that they understood more would be, I think that we're always, I hope that you're working with an attorney that always has your best interest at heart.
Mhm.
You should always, if you don't think that your attorney does have your best interest at heart, then you should not be working with them.
Mhm.
Because being on the defense side and now being on the plaintiff side, I can see that I'll say kind of conflict sometimes. And I've seen how sometimes, on the other defense side, nobody likes to get sued, right? And so when companies hire lawyers, they think, oh man, now I have to pay you and I didn't do anything wrong.
Mhm.
Or, why do I have to pay you to do this work when I don't think I did anything wrong? And it's a little bit different on the plaintiff side. I think on the plaintiff side, I work with people who more understand that, if I'm willing to help them, or if I take their case, especially if it's on contingency, we're kind of on the same team, right? We want this a good outcome all around. But um, your attorney should be looking out for your best interest. And sometimes that means settling the case, and sometimes that means taking the case further. So I think that's one thing that um, clients should understand, and I hope that they feel and understand from their attorney.
Okay. And I know that within employment law, I mean, there's a lot of different situations that clients can come to you for, but what would you say is the most common situations that a client would come to you for help?
The most common types of cases we have right now would be, um, I would say, disability accommodations in the workplace.
Mhm.
I think that's just a difficult area for employers and employees to navigate.
Mhm.
A lot of employees don't necessarily know how to activate their rights
Mhm.
necessarily. Not that it takes, I don't want to suggest that it takes more than it does, because I think there's an obligation. You would kind of see it as a partnership almost in some ways, the
Mhm.
interactive process. But um, I think that there's a lot of confusion regarding that. And because it's not a black and white test, right? Coming from the sciences, I can tell you, right? Here's this is the test. It either is or it isn't.
Mhm.
In the ADA world, Americans with Disabilities Act, it's this reasonable standard, right? What is a reasonable accommodation? What is an undue burden? Figuring out what those things are is not a science.
Mhm.
And so that's where people really need help and advice navigating those things.
Okay. And I want to dive a little bit more into like some of the most common misconceptions when it comes to employment law, primarily speaking from the employee side, because I've kind of learned a lot more when it comes to this types of employment law and things like if someone has cancer, that can fall under disability, like which I didn't even realize that that's something that it could fall under. But what are some of these other like common misconceptions you hear from your clients or just situations that come up and they're like, oh, I didn't realize that was a thing.
One of the common misconceptions that I think people have is that their employer owes them civility. And that is unfortunately not true, right? An employer can be legally awful,
Mhm.
right, to employees.
Mhm.
And sometimes where that comes up is employees say that they have a hostile work environment. So I hear that a lot. And
Mhm.
obviously a reminder to your listeners or viewers that I'm an Arizona employment lawyer.
Mhm.
So that is, every state has different laws and requirements, and this isn't legal advice, but people seem to overuse that term of what hostile work environment is,
Mhm.
because a hostile work environment based on the color of your shirt is not illegal, right?
Mm-hmm.
Or the type of car you drive, or whatever other situation you could think of that's not protected.
Mm-hmm.
Where you get to the hostile work environment, and if it's based on a protected characteristic or your activation of some sort of employment protection, then you can get to the hostile work environment analysis. But I think there is sometimes still a misconception in people's mind that they have an entitlement to a good, um, happy workplace when
Mm-hmm.
that is not true, right?
Mm-hmm.
I'm a believer, market forces will speak, right? If employers don't want to treat their employees well, then they're not going to have them for long. We live in a world now where people move jobs more frequently than our grandparents did,
Mm-hmm.
right? And so, if employees aren't happy, then they'll leave,
Mm-hmm.
and that's their right to do so.
Mm-hmm.
So I would encourage, and I many times do encourage employees to say, look, if that's the situation you're in, there's got to be something better out there for you than that.
Okay. And what would you say some of the biggest mistakes people make before they call a lawyer?
I think I would say two things come to mind when you ask that question immediately. One is they don't report things to HR when they should.
Mm-hmm.
So I advise people regularly to do that because that is part of the requirement under certain parts of even Title VII, like harassment, discrimination, letting the employer know that you believe that you're being mistreated. And
Mm-hmm.
what's really interesting about that, not to tangent too much, but I do want to mention this. Many times people will complain of harassment, right? They'll say, hey, I think I'm being discriminated against, paid unequally, um, whatever the case may be. And the employer does an investigation, and the conclusion is unsubstantiated, nothing there. Thank you for bringing this to our attention, but there's no discrimination. I'm not going to tell you whether that's right or wrong, but I'll tell you most of the time, that's what happens.
Mm-hmm.
And then after that complaint is where you see the retaliation.
Mm-hmm.
And those are the claims that are more successful, right? And it doesn't matter whether there was underlying discrimination. It's the act of engaging that protected activity of bringing the potential illegal activity to the employer's, front of mind that then sometimes results in that illegal retaliation.
Interesting.
So that's one thing is not bringing it to them, and so it's kind of a catch-22, right? Employees have a tough decision to make in those situations, but the right thing to do is to report it.
Mm-hmm.
And the second thing is documenting things. And this goes for employers as well, right? Being able to document what was said, who said what, the dates that things happen. Um, if there's an email or a text message, not keeping that, whatever the case may be. And caveat there, right? You have to be careful with some employers' policies. You can't necessarily download all of your emails or keep them. I'm not suggesting that, but I am suggesting what you can, log and keep track of. The
Mm-hmm.
better timeline an employee can give me for their case, the better I'm able to present their narrative to the other side
Mm-hmm.
and to advocate for their situation.
Okay. And that's you brought up one point that I want to dive a little bit deeper into the part about advocating, like you advocating for your client. Because I
Mhm.
think when people go to lawyers, I'm sure, and please tell me if you see it differently, but I feel like there's some people that go to a lawyer and they're like, well, I'm only going to share what I think is important because if
Mhm.
I did something that maybe wasn't quite right, I don't want to get in trouble since they're a lawyer and they protect the law when that's really not the case. It's more you are the advocate for them and you represent them knowing the entire situation. You're not trying to get them in trouble if they did something wrong. So they should be telling you everything. Like the more information you have, the better it's going to be. Would you kind of agree with that?
1,000%.
Mm-hmm.
And as a matter of fact, I have it on my intake form that obviously everything that a client tells me is attorney-client privilege. I cannot go to their side and tell or release information that I'm not authorized to release at certain phases of the case, right? We're just talking about kind of theoretically right now. But I will tell you that I cannot advocate effectively if I don't know what I'm up against. If I have all the information at the beginning, it's kind of a trial technique. If you ever heard this before, it's called drawing the sting. It's you, if you know the information first, you want to be the person with the most information, not
Mhm.
the person that's responding to information from the other side.
Mhm.
You want to say, here is the entire story. And yes, we know that this happened. Yes, we know that this happened, but we're able to explain those and work those into the narrative in a better way than if it comes back in a response letter to say, well, did you know this? And then it's like, well, I did not. Let me go talk with my client about that. And sometimes that does entirely change my original assessment of the case, knowing something that I didn't know before.
Mhm.
So it's very important that clients are very forthcoming with everything that we may be up against, and including sometimes things the employer doesn't know about. I've had that come up before. I had once an employee with a situation involving an arrest that
Mhm.
the employee didn't know about.
Mhm.
Only, and we knew that if that was something that was known, it may have impacted that person's ability to continue working there. So
Mhm.
the fact that we knew that though, and I wasn't, you know, responding to that in the next response letter, I think,
Yeah.
helps.
Okay. Now, there's this other concept as far as at will. So basically, my understanding, and please correct me if my basic understanding is that at will basically means the employer can basically fire you for many different reasons, for many different reasons. But where is that line as far as like, hey, I'm going to fire you because it's an at will state and that's my right, versus, hey, I'm firing you and it's under a protected class, or now an employment lawyer needs to get involved because there may have been some wrongdoing or some breaking of the law. Like, where's that line in there?
That's a great question. And it's the the talking point here is an employer can terminate you for any reason, so long as it's not an illegal reason, right? Or said another way, they can terminate you for any legal reason. The at-will concept, I think, is interesting, especially when you compare it to the employment protections that employees have. And they are limited. I will not tell you in Arizona that we're known for having, the most employee protections in the country. But one law that was recently enacted here, the Arizona paid sick time law, it's similar to that in Oregon, I believe, and some other states have similar versions of it. But it's a law that kind of shifts the burden to the employer to say, so here, the general framework is this. If an employee takes paid sick leave within 90 days of the termination of their employment, there's a presumption that that termination was because the employee used the paid sick time that can only be overdone with
Mhm.
clear and convincing evidence. And
Mhm.
that's a very high, clear and convincing evidence
Mhm.
that the employee was terminated for another reason, right? They were caught on camera stealing money from the cash register. They were, whatever it is.
Mhm.
And so this at will concept, especially since paid sick time in Arizona, is for every employee, including employers that only have one employee. It really does change that at will concept, especially since it's for all employees, if that particular situation is activated.
Mhm.
So, yeah, I think that I've heard that get overused a lot as well, right? I can terminate you. I don't have to give you a reason, um, or whatever the case may be, when really that's true, but then you have this whole burden shifting analysis that happens under various employment laws that it doesn't make it quite that simple.
Mhm. Okay. Now, I want to shift topics to pregnancy discrimination. Kind of in your introduction, you're a big proponent of pregnancy discrimination. One of the first things that was mentioned. So, can you talk a little bit more about that? I mean, there was I believe, a pretty well-known case, the PWFA versus the ADA. So, can you kind of talk a little bit more about that, like how things have changed? I guess just what do people need to be aware of when it comes to pregnancy discrimination?
Now, this is where the former teacher in me comes out a little bit. So, if I can just lay the framework here, because I think it's so interesting from a perspective of history and American history and how we've gone over the past 60 years to the point we're at now, right? So, pre 1964, employers could terminate women or could limit their work schedules and say, look, pregnant women can only work 10 hours a week because we think that's in the best interest of the fetus. They can't have certain types of jobs. Sometimes those jobs happen to be the higher paying jobs. We're going to decide what's right for women, and we're going to tell them that this is what, needs to happen in the workplace. 1964, Title VII comes around, and now discrimination is outlawed on the basis of sex, or what is called because of sex, right? But interestingly enough, courts were all over the map as to whether or not pregnancy discrimination was actually because of sex. Some courts said it was, courts said it wasn't. So post 1964, you still had all of these employers continuing to lawfully deny the employees that worked for them, pregnancy leave. They could be fired because they, needed an accommodation, or they couldn't work under certain, conditions, or whatever it was. They needed leave to go to medical appointments. It was completely lawful to still terminate women after 1964. There was a case that was even more detrimental in 1976, GE versus Gilbert. And in that case, the employee sued GE saying, look, I'm a pregnant employee. I should qualify for disability benefits. And the Supreme Court said, nope, sorry, actually, you do not, reasoning that pregnancy discrimination was not sex discrimination, and it doesn't tie in, it doesn't fall into any of the frameworks that have been created so far. Then Congress responded to that 2 years later with the Pregnancy Discrimination Act. So that's the one that most people think nowadays. They say, hey, well, didn't we already have a law that, banned pregnancy discrimination? Like, didn't we already have that? Well, yes and no, but there were real big gaps that still needed to be filled in, right? So Pregnancy Discrimination Act says that you can't discriminate on the basis of pregnancy, but it basically only said that you have to treat pregnant employees the same as other employees. So if, for example, the employee doesn't offer a benefit to some employees, like, leave or whatever, light duty or any of those other things, then it doesn't have to offer them to the pregnant employee either. It just basically kind of leveled the playing field to say, okay, pregnant employees need to be treated the same as other employees, which really, I think, if you look back on it, I don't know how it really doesn't do enough, right? At least from my perspective, it really doesn't, right? For what the needs of a pregnant woman are, especially in the workplace. So somewhat related, you have the ADA. So it's 1990 comes around, right? And says, okay, here, we have Pregnancy Discrimination Act. We have ADA 1990 that says you can't discriminate on people on the basis of disability. But again, right, remember, pregnancy is not a disability. So in order for a woman to activate that type of protection or accommodation in the workplace, she'd have to have something like gestational diabetes or preeclampsia, or something that was actually some other type, ironically, of medical condition before she could activate the right to accommodations, leave, whatever other benefits, were offered, that she could get. So this is why the 2023 PWFA is so important, because it really filled in that gap for pregnant women to say, look, we're not trying to fit the pregnancy into these other systems that were created, to kind of for other situations. What we're saying is women who are pregnant need reasonable accommodations in the workplace, period. Right? Not we need to be treated the same as other non-pregnant employees. Pregnant women in the workplace need to be able to activate reasonable accommodations. And so that's something like if they need to be able to take a sitting break, if they need to be able to use the restroom more often, if they need to have, and this includes post-birth situation, right? So if they come back after pregnancy and they need to be able to have a quiet space to pump or lactate or whatever it is that they need, that needs to be discussed with the employer, and they have to be accommodated. And again, it's reasonable accommodations without an undue burden. I'm not suggesting that all of these things are like a list of demands an employee can walk into and say, you have to do these things. Every job is different. Every job has different requirements and scenarios. But one case that might really kind of show that point exactly is like a job where the employer requires the employee to be standing all the time, right? Like for whatever reason, whether they're checking people out at a cash register, or they're greeting people at the door. And pre-PWFA, it wasn't okay or required for an employer to say, yes, we can accommodate with a stool or a sitting break or whatever it is because you're pregnant. right? It might have been under the ADA if the person had a disability,
Mm,
but not if it was because of pregnancy.
mhm,
So there was a gap there that is now addressed by
mhm,
this new law, relatively new law. And I think that's what's so interesting about that legislation. And that's why I thought it'd be a good thing to kind of, talk about and address um, here on this podcast.
mhm. Now, do you feel like the law is kind of going in the right direction to handle pregnancy discrimination? It kind of sounds like it is, but do you feel like it's going far enough? Do you feel like it's on a good path? Or do you feel like, I guess, how do you feel about like where the direction is going to protect people for with pregnancy?
I think it's going in the right direction in terms of what we can see on paper, right? I think that everyone has to be aware of how these things impact human beings and how it impacts people's businesses and people's ability to earn a living. I mean, we obviously still live in a country where we don't offer, that as much leave as a lot of other countries and things like that, which I don't want to get political on this podcast. I don't want to go in that direction, but I'll tell you that I think on paper, these accommodations are what needed to happen, right? This law was long overdue. To think that we went from 1964 addressing discrimination in the workplace and only in 2023 are we actually effectively trying to manage pregnancy in the workplace is pretty mind-blowing. This is the first law that put women and pregnant women first before saying we're going to try to fit you into one of these other categories and see whether, you fit into the Title VII or do you fit under the ADA or where do you fit? This was the first law that was focused most on what does a pregnant woman need to be able to keep her job? Because I think, and I'm not an economist, right? I'm not a very effective historian here, other than on some of the case law here, but I would say, from a 1,000-foot view, you want to have a society where you allow men, women, pregnant, not pregnant, to work, right, and to contribute to their families, and for women to be financially independent if they need to be, right, and to be able to support their family just as men can or do
Mhm,
without the and I don't want to use the I will say without pregnancy,
mhm,
right? It's a wonderful thing. It's a blessing. It's not an obligation or burden, but it is something that should not be penalizing women in the workplace,
mhm.
from
Okay.
achieving or making or earning a living.
Yeah. Okay. Well, glad to hear that you feel it's going in the right direction at least.
Right.
Okay.
Right.
Now, Shayna, let's say that somebody is looking for some help. They had some issues in the workplace, they were fired, or they're facing discrimination, whatever the reason, they're looking for a lawyer. But
Mhm.
they've never worked with a lawyer before. They don't know which one to choose. They just don't know where to start.
Mhm.
So, what is the most important piece of advice would you give to this person as they're doing their search so they can find that lawyer that they feel is a good fit, is knowledgeable, has the experience, and can help them get the end result they're looking for?
Well, first of all, I would say find the right type of lawyer, right? So, because I think, I mean, when I went to law school, I wasn't really sure and because I didn't have any lawyers in my family, right? I understood generally it was criminal law, I understood there was civil law, but right under civil law, which is what I do, right? There's so many different practice areas. So I'd first of all say look for a lawyer that is has a lot of experience in the practice area you're looking to have help in. I do not do workers' comp, for example, right? Some people think, oh, employment law, no, workers' comp, that's more like injury type on the job
Mhm,
type representation.
mhm,
So first of all, it's finding the right type of lawyer. Second, and I think this is what makes our firm a little bit unique. I don't just do one type of employment law. My experience is very broad.
mhm,
And many times I've had people come to me with what they think is a discrimination claim, right? Hey, I think I was discriminated in the workplace. I was let go when, I raised this issue. You also raised this other issue. And I can't tell you how many times that's turned into a wage case, right?
Mm-hmm.
Where I discover in talking with them, well, they were classified as salary, but they should have been really getting overtime because they weren't in an exempt position. So that's a whole nother area of employment law. So if you think you have an employment claim, my advice would be to talk with really an employment lawyer. Employment law is not really the thing I think people should dabble in. There are too many laws and requirements and regulations to be able to really give your client the best advice all around
Mm-hmm.
and know what it is that their real claims are before they time out, because employment law claims have short statute of limitations.
Okay. Now, there's this concept that I want to get kind of your thoughts on is that when you're looking for a lawyer, there's
Mhm.
the lawyers that you really like, that you really connect with, that you really get along with. And then there's the lawyers that have kind of more the experience, they have the ability, and they can basically help you win the case, let's call it. So obviously you want to have both if you can, but if you're in a situation where you have a lawyer you really, really like and connect with, but maybe they don't have as much experience, and another lawyer who has lots and lots and lots of experience, great track record, but maybe you don't like them as much or don't connect as much. How do you kind of determine which way to go between that likability and the connectability versus the actual ability of the lawyer to get you the end result you're looking for?
Oh gosh, I would say neither one of those is a great situation to be in. Because you do want to at least be able to trust. Like I said, I think trust is such a fundamental part of effective representation that and if you can have enough trust, I guess it's personality dependent. So that's a really hard question to answer because some people are absolutely fine with not having, an attorney that they get along with or have, I think that's very, very specific to the person who and what they need.
Mm.
Um, and yeah, I mean, I've had clients, I'm just trying to think of my experience here, some who don't necessarily want to hear from me unless something's happened, and some who like to hear from me, every week, and that I just think people are different in their needs. And so I don't really know that there's a advice I would give there because everyone's really different.
Okay. So it just depends on what they prefer.
I think so because I mean, I certainly wouldn't go with someone just because you find them easy to talk to, you get along with them if they don't have the experience.
Hmm.
I mean, I certainly wouldn't recommend that.
Hmm.
But I would say that a lawyer also has ethical obligations to only take cases that they believe that they can effectively handle and represent their clients on. So, you know, um, if anyone ever comes to me, let's just say a friend or a family member in an area that I'm not well versed in, I'll point them in another direction and say, this is an attorney who, I'd be more than happy to stay on, communicate, help you, navigate or just be a soundboard for you on certain things. But, I don't think it's a good idea to take on cases if you don't really have the background in that area.
Okay. Okay. Now, Shayna, I'm sure that throughout your experience, you've had a lot of memorable cases or even challenging cases. Is there maybe one story that comes to mind that you could share of just one of those memorable or challenging cases and how you were able to get them a great outcome in the end?
The case that really put me in the tradition of representing employees is pretty memorable. So I think I'll talk a little bit about that one. That was a case, it was a sex discrimination and harassment case.
Mhm.
And at the time that I took that case, I can say that it went for a much longer time than anyone thought it was going to go on for. But it was one of the first plaintiff cases I had taken and it did not feel like work to me. So to me, that was a very memorable part of it. It felt like I was helping someone and trying to get a really great outcome. And I really enjoyed working on that case. So I would say that case stands out to me. It went through, I think, 2 rounds of mediation before it ultimately did resolve, but it did resolve on the cusp of summary judgment. And that case is pretty memorable. I had another case where an employee was injured on the job I wasn't handling the injury portion of it, but it was a situation where they got their finger cut. I won't say off, but we'll just call it a hand injury. And it was an accommodation issue. This person needed to be able to use their hands
Hmm.
to do the type of job that they were doing. But it was a very large factory where they very easily could have gone to another position, right? They didn't need to be doing that particular type of activity.
Yeah.
And that case was really memorable because the employee was, um, I would say that it meant the world to him to have representation. And I think that case, that client gave me a coffee mug, and I still
Mhm.
look at that coffee mug every day, and I think of, how great it is to do the job that I do for people
Mhm.
sometimes. Um, and I think pregnancy discrimination cases, sexual harassment cases, all of those, some of those facts are, I don't know whether they're appropriate to share, but I've had statutory rape situations where you're very young female employees were statutorily raped by much older managers
Mhm.
at companies, right?
Mhm.
And the situations and fallout from those terrible situations are obviously very memorable and impactful.
Mhm.
Um, so yeah, I mean, and this is the part about employment law is it is very interesting, right?
Mhm.
These are
Yeah.
humans, these are people's lives,
Yeah.
and ultimately what you're dealing with is the decisions that people make,
Mhm.
right? And whether the company knew about the relationship, the sexual relationship, whether they did anything, whether
Mhm.
they should have done anything, what
Mhm.
they should have done to
Mhm.
prevent that from happening.
Mhm.
Um, those cases are very memorable, and um, you know, I really do enjoy representing and trying to help resolve those situations for my clients.
Yeah. Well, I can just tell it's you
Mhm.
really are that guiding light for them. Like they don't know what to do, they don't know who to turn to, and you're able to help them resolve in many situations a very serious situation that's happening in their lives. So I think it's a
Mhm.
very powerful thing, and I guess why it sticks with you because you're helping them out of something that they just didn't know how to get out of.
Right,
So
right.
now, Shayna, with your own practice, like what's your vision for your practice?
Oh, I actually have got kind of a 5-year plan. I'd love to be able to grow, to have a couple more attorneys because, and this is where it comes from. It's not because I have this ambition or goal of getting bigger. It's because the need is there.
Mm.
Um, and it's kind of the interesting shift from being on the defense side to on the plaintiff side that I've mentioned to a couple of my colleagues. The work is there. Employees need help. I only have so many hours in a day to take on as so many cases.
Mhm.
And as on the plaintiff side, I think a lot of plaintiff employment attorneys try to share cases if they can. Like, hey, this great case came in. I can't take it. Can you take it? I think that and I think from a financial perspective, that's where the challenge is because we know that we're up against a steep, hill and burden of proof on most aspects of employment law. And so, to take these cases, and largely I do contingency fee representation, you have to be able to, stomach that risk
Mhm.
you take with your clients. So it'd be great to be able to have more attorneys doing what I'm doing with me and on the same team eventually. And largely because we'd love to expand the ability to help more people.
Awesome. Okay.
Mm.
Well, Shayna, I do have one last question for you, but before I ask it, I do want to point people to your website at fernandezwattslaw.com.
Thank you.
Now, last question for you.
Mm.
What does peace of mind mean to you?
That's very deep. Peace of mind. What does peace of mind mean? I think to me, because I have a family, it means that my family is healthy and happy pursuing what they want to do and their passions and that they and that every and I'll add one more caveat to that before I get too wordy with this, and that's having the opportunity, an equal opportunity to pursue one's dreams and and ambitions. Because I think that fundamentally, if we get really philosophical, is what makes people happy. Having something to work towards, having a purpose. And I really love what I'm doing because I feel like this is my purpose.
Well said. Well, there you have it. Shayna sharing her expertise. So Shayna, where can people contact you in your practice?
The best way to contact me is through the website. We have a new client intake form that clients could submit if they believe that they have a case. Again, as we talked about, give me as much information on your case and facts as you can. We can get more later, but obviously need as much as possible at the beginning. And then from there, we can reach out and see if we can help you.
Awesome. Okay. Well, Shayna, this is great. Thank you for coming on, and thank you for sharing your knowledge and expertise.
Thank you, Daniel. Yeah, great to be here. Thank you so much.
Thanks for listening to the Verdict Signal podcast. Any questions? Please contact the practice directly with the contact information provided during the show. We'll see you again next time. Bye for now.